The new Immigration and Foreigners Bill 2025, aimed at overhauling India's immigration laws, was introduced in the Lok Sabha on Tuesday. How does this bill propose to change the existing immigration framework in India? I, Apoorva Mandhani, will tell you in this video. Now, the bill repeals and replaces four existing laws. You can see the laws on your screens right now. So, the statement of objects and reasons of the bill pointed out that three out of these four laws are not only of pre-constitution period, but also that they were brought into extraordinary times of First and Second World Wars. It said that this new law is being brought in to avoid multiplicity and overlapping of laws. Now, let me take you through the provisions of this proposed law. A significant provision of this bill is that for the first time, it bars the entry or stay of a foreigner on the ground of threat to national security, sovereignty and integrity of India, relations with a foreign state, public health, or other such grounds as the central government may specify. So, foreigners, of course, have been denied entry before, but now this has been given legal backing on these new grounds. The bill also bars departure of anybody from India if his presence is required in India by any authorized agency. Additionally, it explicitly allows for collection of biometric information of any foreigners along with the existing requirements of collecting their photographs, specimens of handwriting and signatures. This potentially expands on the existing practices in visa processing while providing statutory backing to collection of such biometric data. Now, while the existing laws grant powers to the central government pertaining to the entry, stay and exit of foreigners, the proposed law clarifies and expands on these existing provisions. Let me give you examples. For instance, the bill allows a police officer to arrest without warrant any person who may have entered India without valid documents, or even if there's a reasonable suspicion that he has done so. Such a power was not a part of the Foreigners Act 1946. Similarly, the Registration of Foreigners Act 1939 provides for registration of foreigners entering, being present in, and departing from India. The new bill now mandates immediate registration of foreigners upon their arrival in India. Additionally, while the 1946 law primarily focused on the individual foreigner's responsibility to register themselves with the authority, the new bill also places significant new obligations on institutions to report information about foreigners to registration officers. So, Clause 10 of the bill makes it an obligation of every hospital, nursing home, or any other medical institution providing medical, lodging, or sleeping facility in their premises to furnish information in respect of any foreigner taking indoor medical treatment or their attendant for whom such lodging or sleeping facility has been provided. Clause 9 of the bill places a similar obligation on universities and educational institutions as well. Now, in addition to all of these provisions, the new bill also introduces stricter fines and punishments. For example, the Passport Entry into India Act 1920 regulates the entry of foreigners in India. The new bill says that any foreigner who enters into any area in India without a valid passport or other travel documents like visa shall be punishable with an imprisonment of a term which could extend to 5 years or with a fine which could extend to 5 lakh rupees or with both fine and imprisonment. The penalty for using or supplying forged or fraudulently obtained passport or other travel document and visa ranges from 1 lakh to 10 lakh rupees. Now, the Immigration Carriers Liability Act 2000, which is one of the laws that is currently in place, it was aimed at making carriers also liable for transporting passengers into India without valid travel documents. This law, 2000 law, had said that a penalty of 1 lakh can be imposed on such a carrier. Now, the new bill increases the fine to a minimum of 2 lakh and a maximum of 5 lakh. It also says that if such a penalty is not paid, the civil authority or the immigration officer can recover it by seizing or detaining the aircraft or the ship, or by seizing, detaining, or selling any goods or properties belonging to the carrier. Now, also in a departure from principles of evidence law, the bill places the burden of proving whether a person is a foreigner or not on the person whose legal status is under challenge. But this is similar to Section 9 of the current Foreigners Act 1946 and has just been retained in the new bill. Additionally, while we already had a Bureau of Immigration, which was established in 1971 as a department under the Ministry of Home Affairs, the new bill provides legal backing to this bureau and also explains the functions of immigration officers. So, the financial memorandum attached to the bill acknowledges this and makes it clear that a Bureau of Immigration with officers is already in place and functioning. Therefore, the bill is not likely to involve additional expenditure from the Consolidated Fund of India. That's all I have for you today. This is Apoorva Mandhani for The Print. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.